Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning.
Morning, everyone.
I'm Hilary and with me is Deidre Khayamian. We're both lawyers at SpringLaw. And it seems to have people coming in, but they're rapidly coming in, so I'll just do our little intro. Welcome, everybody. So this is Spring Forward, our monthly webinar series, Spring Forward Legal Updates. Today is our fifth of our 2021 monthly webinars, and we are discussing post-pandemic resignations. So there is a little handout for you to download, which is just the PDF of the presentation we'll be going through. So you can download that PDF in the handouts tab there. And if you have any questions as we're going through it, you can pop them in the chat and we will do our best to answer them as we go along, while being mindful of our half-hour timeline here. So, right, so I'm Hilary Page, as I mentioned, and this is Deidre Khayamian. As I said, we're both lawyers at SpringLaw. And if you're one of our clients already, you already know that we are a virtual employment and contracts lawyers, virtual employment lawyers, and we're based out of Ontario. Welcome to those of you who are new to the webinar. And if you want to learn more about us, you can go to our website, springlaw.ca. We've got lots of free resources on there. So we've got our weekly award-winning blog posts. We've been posting lots of stuff about the pandemic. As you all know, the law has been changing rapidly through the pandemic, so we'll keep you up to date on all of that there. We have a downloadable publication, the COVID-19 info for employers, so lots of information about all the different programs, common questions. You can subscribe to our newsletter on there and learn more about our innovative subscription program for employers, or check out our ebook for recently fired employees looking for an alternative to in-person legal services. This is just our legal jargon, basically just telling you that we're providing you today with legal information and not legal advice, and that this attending the webinar does not create a solicitor-client relationship between us. All right, and over to you, Deidre.
Thanks, Hilary. Thanks, everyone. So today we'll talk about why wave of post-pandemic resignations is being predicted. We'll look at some post-employment obligations on employees, confidentiality, non-solicits, non-competes. We'll also talk about waiving an employee's notice of resignation, providing references to a departing employee, takeaways of the presentations, and then at the end, Hilary will give an update about COVID updates that are relevant.
Okay, so I'm sure lots of people have seen these headlines, but many outlets are predicting a resignation boom post-pandemic. So we're going to talk a little bit about why. Some people are saying that the pandemic gave employees an opportunity to explore their new passions and priorities. So all of this forced downtime, I think, has made people re-examine their priorities in life and maybe decide it's time to write that novel. I think there's also just a backlog of resignations. People tend not to want to change their job when there's instability, as there has been during the pandemic. So there's just pent up resignations for that reason. And then there's the thought that, which Deidre will go into a little bit more, but with all of the sort of changes we've seen to the workplace, that there might be better or more flexible or different opportunities for people in the post-pandemic job market.
That's right. Many are suggesting that employee resignations will be fueled by the employer's demands to return to the office, to the old, less flexible way of working. Some employees would rather quit than go back to the office. There's also a potential boom in post-pandemic hiring, which may give employees new opportunities to go elsewhere where they can continue working remotely or negotiating some flexibility into their work lives. Reason for this idea that there are better opportunities that might be out there is that nearly 7 in 10 employers globally are struggling to find workers to hire for specific positions. So that could be one explanation.
Right, and so I think the thing that employers maybe want to think about when they're saying, lots of employers are eager to get back to the office, but if a senior employee is going to leave, if they have to come back to the office full time, is that really the right move, right? Because I think we are going to see more flexibility in workplaces just across sectors. So once your employees resign, what are employers' obligations when an employee quits? So there are things that an employer wants to think about when their employee has given notice of resignation in order to protect the business, right? So they're sort of similar to what you want to think about when terminating an employee, but there's the tenor is a little bit different, right? So because you don't necessarily know when an employee is going to resign, so you can't necessarily prepare in the same way as you would if you were terminating somebody. So they're just, it's important to actually have a protocol in place for when an employee resigns. What are we going to do? And the things that employers mainly want to think about protecting are the risk of the employee walking away with confidential business information or taking some sort of digital data, right? So, So Deidre's going to talk, or we're going to talk more about resignation periods, but there's that period often. If an employee says, I'm resigning and I've given you my 2 weeks, what are they going to be doing in those 2 weeks, right? When you terminate an employee, generally you cut off their access to their email, your server, and whatnot right away. So you need to turn your mind to those things when an employee quits as well. Hopefully employees are trustworthy and these aren't really big deals, but if there is a specific concern, you want to have those protocols in place to ensure that you're protecting your digital information from possible theft by the employee.
So an employee's duty of confidentiality either comes from the employment contract or the common law. Well, it's always there under the common law. Employees have certain common law obligations, and by common law we mean judge-made law that continue following the end of their employment. Most significantly is the duty of confidentiality to protect employer confidential information. This means employees cannot reveal employer confidential information or tell their secrets to a competitor. Employees should be reminded of this obligation on their way out. So if your employee is resigning, you can find an opportunity to remind them of their confidentiality obligations before they leave. So as I said, a confidentiality is like another restrictive covenant that you might have in the employment contract, and that will prohibit the employee from disclosing confidential information about the employer, which they learned during the course of their relationship. Anything that they come to know just without, supporting with documents obviously their know-how that they take with them, but they can't be disclosing anything that's proprietary or that would be understood as trade secrets of the employers when they leave.
Right. And I think the sort of a common example that we give of confidential information would be like if the employer had a list of potential clients and the employee actually walked away with that, right? That would be confidential information. Maybe they can remember who some of those clients are. That may or may not be confidential, but if they actually took something like that, that would be a breach of their duty of confidentiality.
And then we'll talk about two others. So other restrictive covenants are non-solicitation and non-competition agreements. So that list that Hilary just mentioned in their head, that client list, if you wanted to stop an employee from using that, you would use a non-solicit, non-competition agreements in order to do that. Employees get in-depth knowledge of their employer's business, and they may develop relationship with an employer's clients while they're working. The restrictive covenant minimizes the harm which could be caused if the employee decides to use or disclose information for their own benefit or to the detriment of the employer. So with a non-compete or non-solicit, you can restrict a departing employee's ability to compete with their employer or solicit clients or employees. However, the limits that are placed in these agreements need to be reasonable because courts usually find that they are unenforceable. You don't want to over-restrict and prevent someone from being able to work. Typically, a non-solicit agreement will prohibit an employee from soliciting clients, customers, employees, or any others who the employer had business dealings with. And a non-competition covenant just broadly would prohibit an employee from starting a business which is competitive to the employer or accepting work or becoming the employer's competitor.
Right. So these things need to be in place already. So you couldn't like have an employee sign one of these after they resign in most circumstances. So just noting that they're typically something that you'll have an employee enter into when they're signing their employment contract. So at the start of the relationship, or if you want to introduce one sort of mid-relationship, you need to give new consideration for that. So something of value to the employee in exchange for putting this restriction on them. So often, as you said, they are, technically kind of unenforceable or questionably unenforceable, but they do typically have a deterrent effect. So they are a good idea. So what can an employer really do if they do have these types of concerns? The first thing is definitely, as Deidre said, remind the employee of their obligations. So, it's difficult maybe to do this in a tactful way, but you can ask a resigning employee where they're going or what their plans are, obviously being just friendly. And if any red flags are raised, you could raise that they do have a restrictive covenant that might prevent them from working there. If things get a little bit more serious, we often send a cease and desist letter to the employee. So this would be, again, saying you're in breach of this agreement. And we can also contact their new employer to let them know, hey, you've hired someone who's breaching an obligation, and that can create problems for the employee at their new job. So hopefully none of these things happen, but those are kind of typical things that happen. In really serious cases, we might bring an injunction, which is a legal mechanism that stops the employee from continuing their breach of that agreement. And those typically arise more in situations where it's like, a dentist leaves a dental practice and opens a competing dental practice right beside it and takes all the clients, that type of situation where it really does have likely a really big impact on dental office number one. Those are kind of the serious types of situations where an injunction might actually be warranted. I'm just looking, there's a question here. I've always heard non-competes aren't really enforceable. What's a reasonable restriction to prevent someone from working for a competitor? Is it based on how senior their role is? So the restrictions need to be reasonable in terms of length of the restriction, so for how long it's in place after the employee leaves. And the seniority of their role or their centrality to the former employer is going to be an important element of that. So in maybe a really senior role, a year or 2 years might be reasonable. Generally, nothing beyond 2 years is ever going to be reasonable. They also need to be reasonable in terms of the activity being restricted. So it couldn't be, if you're in the tech industry, it couldn't be like working in the tech industry. It would need to be more narrow. So specifically, like, building vaccine finder apps in the tech industry or something like that. And then it needs to be reasonable in terms of the geographic restriction. So this is kind of a place where I feel like the law hasn't really caught up to the digital age, because often where we physically are doesn't really matter. We can, work for clients all over Canada or all over the world. But typically the geographic restriction is it needs to be reasonable. So like the Greater Toronto area or something like that. And it all needs to be reasonable with a view to what the activity is, right? So in my dentist office example, it's reasonable maybe to put a restriction on a dentist that's like 10 kilometers or something, right? But if you have another dentist in Toronto, who cares? That's probably not going to be reasonable, just because there are lots of dentists in Toronto, right? So yeah, another example would be where there's a purchase of a business and the former owner of the business stays on to run the business for the new owners. That's a situation where like that person is super senior, right? Because they built the business, they have all that internal knowledge. That's sort of an example where restrictions will be really reasonable because they built that business. They could just go build another one that's going to be competitive. All right, moving along here.
So now we'll talk about waiving the notice of resignation. How much notice can you expect? So in Ontario, there's no minimum statutory amount of notice of resignation that employees are required to provide. Practically, this means an employee could tell you that they're resigning immediately or that they're resigning in 5 months. Talk to the employee about how much notice is reasonable. If the employee has an employment contract, this may say how much notice is to be provided. If it does not, ask the employee if what he or she thinks is reasonable. But in the absence of an employment contract term, there is no statutory obligation on them to provide a minimum amount of notice. While many employers find soon-to-be ex-employees to be a liability in the workplace if they continue on, in certain key roles, a company may actually have a hard time running without them. And depending on the employee's role, they may have a duty to make sure that their transition is smooth and that no harm comes to the company from their departure. So reasonable notice for departing key employee has been held to mean the amount of time it would take the employer to hire and train a replacement.
Right, so like Deidre said, so there's no law, that says 2 weeks notice is required. So an employee could really be like, I'm leaving tomorrow. They might be in breach of their contract if their contract says you need to give 1 month of notice, but in most cases, the employer's not really going to have any recourse. You can't really force someone to keep working necessarily. I think the exception, as Deidre just said, would be with those key employees, where they can actually have legal liability for not giving enough notice if their absence actually like creates a big problem for the business and causes an actual loss to the business. So So there are decisions about this. This has been litigated. So in an extreme situation, an employer could take their former employee to court for failing to provide reasonable notice. So hopefully that never happens to you, but if you are in a, if an employee doesn't give enough notice, there's perhaps a little bit of leverage there in having that conversation. Obviously, you don't want to threaten to sue someone unless it's absolutely necessary, but they do have that duty to provide reasonable notice if they are really a crucial employee. And a crucial employee is going to be someone who's not easily replaceable, right? So if it's like a lower level job, likely they're not going to be key in the eyes of the law.
Okay, so that's too little notice. Some employers feel there are situations where it seems like there's too much notice and an employer wants to ask the employee to leave early. Especially because if an employee is departing, you may not want them to stay on the payroll. Typically, the thinking is that employees who are resigning won't be motivated to work, or that there'll be a liability in terms of stealing confidential information, which we've talked about, or cause a morale dip on the team, right, among the employees who are being left behind. Employers can typically safely waive an employee's notice of resignation and ask them to stop working early. However, they will probably still be entitled to be paid until the end of their specified notice period.
Okay. So if an employee is leaving and they haven't already got a job, it's likely they're going to ask for a reference. And sometimes employers don't want to give a reference. When we terminate an employee, the employer's liability to that employee is impacted by how quickly they get another job. So we want to help them get another job. In termination situations, when an employee resigns, the employer doesn't owe them anything, right? Doesn't owe them any notice or anything like that. They do owe them their accrued and unused vacation pay, so I won't say I don't owe them anything, but there's no notice. I think that's actually a common misconception of employees. They think like they get paid. A lot of employees think they should be paid to quit. They're not. But if an employee asks you for a reference and you're not really crazy about giving them one, in the quitting situation, there's no real obligation on the employer or necessarily any benefit to the employer to providing an employee with a reference. Obviously, it's a nice thing to do, but there's no obligation there. And if a former employer is called for a reference, often employers are wondering, can I be truthful, or is that going to cause some problem for me, right? Like if I tell this potential employer, actually this guy was always late and he doesn't get the job, could that former employee come and sue me? And anyone can sue anyone for anything, but they wouldn't be successful as long as the employer was being honest, right? So employers can provide honest references is sort of the takeaway here. Obviously, you need to think about your reputation if you're foisting a bad employee onto another business, right? It's a great Curb Your Enthusiasm episode about that.
So just to
sorry, Deidre, go ahead.
Right. So just to recap, so you should prepare for, if there is a post-pandemic wave of resignations coming, you should prepare for it. Prepare to have conversations with employees who are exiting. Know that some employees may not want to give up remote work, and consider maybe before you receive a resignation whether it's necessary for them to come back to in-person work if you'd like to avoid them quitting. And know that employees, if they do resign, have post-employment obligations in many cases that are critical to your business, like confidentiality, non-solicit, non-compete. Remember to review those if you have them in place before the employee exits. Under the common law, even if you don't have an agreement, there is a common law duty to keep your employer's confidential information confidential. There is no statutory minimum notice an employee has to give, so keep that in mind. And if you do waive notice, that doesn't mean you don't have to pay the employee for the time they were supposed to work. Letters of reference, as Hilary mentioned, you want the employee, to find another job. So they're important to departing employees, and they can go a long way in parting on good terms. You never know in the future if you end up continuing to work in the same area or work together again.
And I see we just got another question. If the contract does not have a resignation notice provision for the employee, and if the employer asks the employee to leave immediately, what is the basis for any liability for the employer? So in that case, the employer typically is going to be liable to pay the employee to the end of the notice period they provided, right? So if the employee said, I'm quitting, my last day is going to be in a month, and you wanted them to leave immediately, you would still owe them pay for a month. The basis being basically is that if you ask them to leave earlier, you're basically firing them, right? Let's see, another question. If you provide a reference for an employee that is not truthful for fear of legal ramification, is there any risk in not being truthful in the reference you provide? I guess in terms of thinking about the risk here, when we think about risk, I always want to think about like, well, what might you be getting sued for? What loss was caused here, right? And then what was your duty to prevent that loss? I suppose there's possibly very minimal risk, I would say, but if you told another business, yeah, this guy is great, and they relied on that, and then this employee, ruined their business and cost them hundreds of thousands of dollars, maybe there may be some liability because you didn't, they relied on your reference that was a lie, but I feel like it's pretty tenuous. So it's probably not a great amount of risk, but it's a good question. I'm just going to put these COVID updates up here. So this was a presentation not about COVID for a change, but a little bit about COVID. But we did just want to flag there's lots of sort of COVID action going on in terms of subsidies and the infectious disease emergency leave and whatnot. So the deemed infectious disease emergency leave, it was to end on July 3rd. It's been extended until September 25th, 2021, and that's the leave that's applicable to employees whose hours of work have been reduced. So people who are what we would normally call laid off. This is the deemed IDL is the mechanism that's allowed those layoffs to continue for a long time. The paid IDL is now in effect, so this is the new sort of paid sick leave that was introduced in Ontario, I believe, in April. So this allows employers who don't otherwise provide any sick days, paid sick days to their employees, to be reimbursed up to $200 a day when they provide employees with paid sick days for sort of COVID type reasons. So like getting a vaccine or something like that. Gives the employees paid time off in order to do that. The wage subsidy, it's so the last period for the wage subsidy would have ended on June 3rd. but it's proposed to be extended another period until September 25th. So I don't believe that that has actually passed yet, but that's the proposal. I would predict that it will pass, so the wage subsidy will continue. And then there's the new proposed Canada Recovery Hiring Program, which is a sort of like a new sort of version of the wage subsidy, I guess we could call it. And I think that will bring us to the end of our program. Thanks for being with us today, everybody. If you did have any questions that we didn't get to, feel free to reach out. And we will be skipping the summer for our legal updates. We take the summer off, but our next webinar will be on September 15th. And details about what that will be on, as well as the registration link, will be posted on our website once we do confirm the topic, and it'll also go out in our newsletter, which goes out monthly. Thanks for joining us.
Thanks, everyone. You can also access our guide for employers during COVID on our website if you want to learn a little bit more about the programs Hilary was mentioning.
Yeah, great point, Deidre. Yes, and then we do keep that up to date. So once these changes pass, that'll be reflected in there as well.